I thought she was here. Senate Judiciary is now in session. We're going to start with HB 1282, an act relative to the duration of child support. And who's coming up? Who's introducing here? You are. And you're Lori Ball?
Yes, I am.
Awesome. Nice to meet you. I am leaving, and Senator Whitley is going to take over because I have to be next door. Sorry that you have such sparse attendance.
That's okay. Thank you very much for having me. I appreciate it. I'm Representative Lori Ball. I represent District 25, which is Salem. The bill I bring before you today is relative to the duration of child support. This is the same bill that was brought last year, and because of a minor change that needed to be done, we're resubmitting it again this year. This bill is really a housekeeping bill in the sense that the way the bill is currently written, it has a giant loophole in it. It says that the child support will end when the child turns 18 or graduates high school. The problem is the child can still be in school, turn 18, quit school, and then never graduate. So it was the turn 18 or graduate, whichever is later. But if they never graduate high school, then they never come to that age. And then we have parents saying when the child is, 19, 20, 22, well, they haven't graduated, so you need to still be paying child support. So what we did as a committee, we looked at this and we went to the Social Security survivors benefits. And that's where this wording comes from, because we said we should be able to align it to another bill. And of course, we went to the Social Security. And that's where it says this exact wording, that as long as the child is a full-time student in high school or secondary, elementary, it's written that way because that is how the Social Security is written. And that they stay there. And then if they don't graduate, we have an actual end date of 19 years and 2 months. And again, we didn't want to touch anything. This is how Social Security does it. If it's good enough for them, we felt that's how we should do it. Further down, this is just to bring this bill brings into alignment the change of law that allowed special education to now go beyond age 21. It goes to age 22. We originally were putting in here to say actually age 22, but rather than doing that, we just wanted to align this with the bill in case that age of special education ever gets moved to 23 or a different age, so that this would automatically change and stay in alignment with that law. And with that, I'm done with my testimony. That's okay. Totally understand that. There's no questions? Okay, thank you very much for your consideration.
Excuse me, Matthew Hayes Best.
Thank you. Matthew Hayes for the Bureau of Child Support Services. I'm employed there as a staff attorney and legislative liaison. I just want to let the committee know that the Bureau does not have a position on this bill. I put neutral down on that. We believe this is a policy decision that's best left to the legislature. But we just wanted to point out on the record that we did submit a fiscal note. And we in that fiscal note, we outlined that when implementing this bill, if it should pass, there are a number of system changes we'll need to make, changes in our software. Again, that's outlined in the fiscal note, and there will also be training that will need to be done with the staff and making sure that the staff is knowledgeable about the changes in the law so they can explain it to the citizens when they come in to ask for help with their child support. Other than that, I'm happy to take any questions, if there are any.
Are there any other states that do it this way?
I am not aware of specifics with each other states and what their emancipation looks like. I know that each state seems to do it differently. I have taken a look. You can find some of that information online, and I think that the federal child support guidelines, the federal child support website does keep a list of that information. I'm happy to find it and email it to the committee if that'll be helpful. But you definitely get a whole variety of different ways of doing it.
Thank you.
Seeing none, thank you very much for your testimony.
Thank you.
I just want to, we will call David Bickford, Representative Bickford. Okay. Okay, great, thank you. The chair will call Robert Tangway. Good afternoon, Mr. Tangway. Doing good for Tuesday.
Excellent. Red meat stop traditionally, when I think. So I'm not in support of this bill as inexpedient to legislate. I'm going to go and tell you a little story about a personal experience that I have with a neighbor who passed away who had an autistic child. Title 4D grant money, which the state is clearly addicted to, is a reimbursement for the management of child support and services of such. One of those, some of those stipulations that they can apply for grant money and should be guided by are to encourage marriage, nuclear family, and to get off of welfare services. I think this is Title 4D 601 or 606. I'm not exactly sure, but I can get that to you. I have it written down. So what happened recently, within the last 6 months, is a gentleman at my apartment had 2 children, and one was autistic. And he would go to the pool every day with them, and a product of a divorced planned family. And he ended up dying. And we're not sure if it was a suicide or if it was just a broken heart. Very healthy, went swimming, good shape, and was not a smoker. And then I saw him the day before with his older son, who's in high school, talking as they would walk in the back of my complex. And they were talking about high school, and I've talked to them. They're very friendly. He took very good care of this child. And the thing is that he was not the primary care person or parent. And so what we see is that what I suggest the Senate do to kick this back is realize the actual dynamics of family, current family right now. And what we have are incentives through child support, where statistically we should run a study. You'll find 70% of all divorces are initiated by a woman, and then they get primary custody, and then they also get the child support. Now, child support is a tax-free money, and it's incentive. It's tax-free. So to extend this, I see how it's trying to restrain, but to extend this above and beyond, so the post-secondary school, that's a burden to the other parent when really we should be providing those services in alignment with Title 4D grants and such, so that people are able to get off of government assistance and therefore would not need child support. And that's pretty much my statement on that. Yeah, we need to do a study on the actualization of divorces, parenting cases by gender, because you will discover that there's gender bias, and that is causing a lot of problems in the family. And it's like giving an incentive to one parent, typically the woman, to break up a family, because especially in autistic families, and the story that I told you, they want more free time. So they look at it as, hey, I'll get a paycheck, I will have this kid, my child will be out of my care because it's very difficult to raise an autistic child. Most people are blessed with children that do not have a physical or mental disability. So you'll see that they're kind of like separating. One parent's looking at it as, hey, I can get free tax-free money and I can get a break from the children, go off, date, find, and run away from my problems.
Thank you very much for your testimony, Mr. Tangway. Are there any questions? Seeing none, thank
Thank
you.
you.
Are there any other members of the public that would like to speak to House Bill 1282? Okay, seeing none, we'll close the public hearing. Go ahead and open the public hearing on House Bill 1564 and recognize the current sponsor. Is not here. So you are Representative Wall.
Yes.
Just a little hint, if you're signing in, you should representative. That lets us know that you are a representative, and unless we know who you are, I wouldn't have called you. I would just see that you were a member of the public, and I would have been looking for Representative Katab, or I see Representative Bernardi back there. I would have had him come up and introduce the bill. So please, go forward, please.
Thank you very much. I appreciate you educating me on that. As a first-year representative, I have a lot to learn, so I do appreciate
That's okay.
every opportunity I have. Yes, I'm here to introduce House Bill 1564 for Representative Katab. The Special Committee on Family Court heard testimony on how updates were needed to the child support statute because many parents are struggling to support their children during parenting time, particularly when parenting time was approximately equal and no deviation from the support amount was allowed to offset the costs under the current statute. Despite the recommendations of multiple quadrennial reports advising us that changes are needed, we haven't made any substantive changes to the statute since 2009. Over the summer, Representative Katab and I worked with mediators, several family law attorneys, including the New Hampshire Legal Aid, and we also sought feedback from the court. The language in this bill was carefully crafted based on many hours during multiple meetings and through potential scenarios based on experience of both contentious litigation and amicable mediation. It implements 3 of the recommended changes from the past few quadrennial reports, which the best interest of the child is always at the forefront. First, it increases the self-support reserve from 150% to 130%. Second, it allows for deviations in support cases of shared parenting time via rebuttable presumptions. Third, it shares healthcare and childcare expenses between both parties. Under the current law, if a parent has approximately equal parenting time and makes approximately equal parenting, Parent A's worksheet will show that they share $105 of the parent, while Parent B's worksheet could show that they share $1,005, while Parent B's worksheet shows only $1,000. Parent A has to then pay Parent B the full $1,005, not just the $5 difference. We heard testimony from several parents who were paying child support to their former spouse, whom they shared 50-50 parenting time. and that while they were struggling just to put food on the table, their former spouse was able to take the kids on vacations and to restaurants, and they were just the fun parent. The definitions of approximately equal or substantially shared parenting time are reflective in the choices most New Hampshire parents make when establishing parenting schedules they believe are in the best interest of their child, when each of them wants as much time with the child as possible. This is based on decades of experience from those who are in the working group. This bill passed CFP, the Child and Family Law Committee unanimously, and the House by voice vote. I ask that you please support House Bill 1564 for the benefit of New Hampshire children and families.
Thank you very much for your testimony, Representative. Are there any questions? Okay, seeing none, thank you very much.
If I could just point out my own personal experience, and from what I found it a little bit hard to read someone else's testimony. But what I found is that they're not dividing the difference between the parents' income. So whoever makes more turns over that whole amount to the other parent, and then that puts the other parent in a higher bracket that they entered. Thank you.
Thank you. Okay, the chair, let's see, we'll call Matthew Hayes. Good afternoon, Mr. Hayes.
Good afternoon. Thank you. Attorney Matthew Hayes from the Bureau of Child Support Services. Just wanted to thank you for letting the Bureau testify before the committee on this bill. The Bureau is neutral on this bill. It's not taking a position. We believe it's a policy decision. Changing the guidelines is a policy decision that is best left to the legislature to do. Just wanted to be available and make sure that the committee had access to the 4-year child support review. I believe I have sent it in the past. I'm happy to send it again electronically. I just think that there's a lot of good recommendations in there. Certainly something that the Bureau is required to do every 4 years. The primary goal of the child support guidelines is to best capture what it is, what it costs to raise a child, in that local economy and in that time period. And that's why it's a 4-year thing. It's something that needs to be updated occasionally to take into consideration changes in society and other changes in people's lives. So part of the primary goal, or one of the goals of the child support review, is to take a look at those factors and sort of try to, like I said, capture what's best for most situations and most families. And accordingly, the less you have deviations from that child support formula, the better off, the more successful I think that formula is. And so I think that's what sounds like everybody's trying to do. It's just that's a difficult task to try to accomplish. So, like I said, the less deviations, the better off I think the child support formula is. And that's sort of ingrained throughout that report. And it goes into a lot of different ways of looking at how to set up a formula and how child support guidelines work in different states. And so I would just defer to the information that's in there. This bill definitely tries to accomplish some of that. It looks like it definitely addresses situations where parenting time is equal and the parties' incomes are pretty similar. And it goes into a lot of detail about defining that, which I think provides guidance for citizens and courts and parties and everybody who's interested in child support guidelines. It provides a lot of guidance on those situations. It maybe doesn't provide as much guidance on situations that's a little more mixed. If parties' incomes aren't similar, or if their parenting time is a little bit more or isn't equal. But again, I think that is a policy decision that's best left to the legislature. I will also say, though, as the sponsor pointed out, that it did adopt one of the recommendations with respect to the self-support reserve and upping that from 115% of the federal poverty level to 130% of the poverty level. So it does take that recommendation. But as I stated, I'm happy to send that back to the committee for review, and I'm happy to answer any questions if there are any.
Okay, thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you very much.
Thank you.
Okay. Next, we're going to call Robert Tangway.
Excuse me. I got it right this time. Robert Tangway, father of Ethan Walden and Robert Joseph Tangway, my children, which I have not seen in over a year because of the issues within the family courts, fraud, injustice, lies, and also with the lawyers. I'm in support of this bill. As Dana Albrecht said previously here, what I would take from, though we don't agree on everything, is to bring peace to the family. That's what this bill attempts to do. I do have a couple recommendations, and then I want to go a little bit in depth at the current situation of the family courts and the way not just New Hampshire, but the entire country is looking at the familiar unit. Specifically, if you would take note of page 2, you're looking at 2 at the bottom, subparagraph 1. They say RSA 173B. 173B is unconstitutional via Article 15, right of the accused, is being contested in the Supreme Court right now with the Attorney General and the Supreme Court.
Wait, Mr. Tangway, I'm just looking at this. It looks
Yes.
like it wasn't amended by the House. So I have the copy as introduced.
That's what I have as
Okay,
introduced.
because you said page 2, line 23. Okay, I see.
On some good old fashioned legal pleading paper.
Okay.
So
Thank you.
173B is, now I'm not saying domestic violence is correct, but it's a crime. They call it an act in 173B, but a pickle is still a cucumber. A crime, if you call it an act, is still a crime. Therefore, it has to go through due process. 173B removes liberties such as parenting, money, time with your children, freedom of movement. You can't have without due process. No lawyers, if you can't afford one. No rules of evidence, hearsay, and in my specific case, known physically and mathematically impossible findings of fact, fraud. So you got to remove 173B, and then this is very important. RSA or Chapter 546, made in 1955, is the Uniform Civil Liability for Support. It was updated in 2014 and 6. I'll go into that a little bit more, but basically what it says, if you go to section A6, wealth shall be considered assets are wealth in determining child support. So what we need to do is, instead of having 173B in there as abuse, because it goes into saying unpredictable work schedules or cases where there is evidence of abuse as defined in 173B, which is unconstitutional. Scratch that and say, or special circumstances such as RSA 546A5. And that will allow them to determine wealth. And the whole goal of this chapter is to, and it's the founding chapter, which is acknowledged, is to make sure that the children have equal living situations. So when you break up a family, you bring a child, and a child goes somewhere, and a lot of times that's determined, even though it's not supposed to, by 461A, parental rights and responsibilities. It goes to show, the kid ends up with the person who has the house, and then the other parent, which is me, kicked to the streets for no reason, is basically bringing them to Burger King or Chuck E. Cheese and having to pay child support, tax-free money. Wealth shall be considered. It says shall be considered in there. The judge has no jurisdiction. What we need to do is come up with laws that determine guidelines for the determination of wealth. Because you have alimony, and then you also have child support. Alimony is well settled, child support's not. So now I'm going to go into the family courts. Family division, 2005, came from a test pilot program. Family courts in 2011. We don't know, family law is not settled yet. This is how it needs to be figured out. Because the family is an asset. The family is an intangible asset. The family name, my name, Tangway, is a piece of intellectual property. And that's how you get defamation. So if someone lies about you and says some things about it, they're defaming your name, your last name, my children's last name, because they took them. And this was a planned family. So when someone breaks up a family, the way we need to be drafting our laws to lock and stop the bias in the courts is they have to look at it as the person is breaking up the family. There is not a no-fault divorce. A no-fault divorce is unconstitutional. You are breaking up a family. You are causing damage. You are torting. You are saying, I don't want to be with you. And this is typically because loss of attraction. A woman can go, in most cases, they can go post on Facebook or Instagram, and they can go and acknowledge, and then some guy will come move in. And how this actually works out with child support is that then when the two parties move in, right, all a woman has to do is, right, I'm single, come move in. They move in, collect child support, maybe they have other children, but the child support follows wherever the money goes. And then in this specific case, in my case, without stating names, the person that she went with was in a family with one child, then had a child. So that person was getting assets because they were paying tax-free money, child support to the mother of the other party, right? It goes in, right? They're building up assets. They have a divorce, they split it. But then now this mother has 2 child support payments and an alimony payment. And it's causing incentive. We need to stop the incentive and look at it like, hey, we don't want you to get a divorce. You should work through this. You made a covenant to have children, and you made a specific choice to create children. You cannot simply split that up. And then that goes into divorce too. So just to reiterate, we need to go over 546B because these matters have already been decided. Child support was created in 1935, I believe. Okay? Wasn't updated until like the early 90s, and then 1996, 2001, 2005. They kept updating it federally because of all these issues that we're having. We're giving an incentive for people to split up families, which is against Title 4D. Children do best with both parents in a nuclear family. We need to save that. And then the person who is deciding to break up that family is abusing the children and abusing or hurting the other party, unless it's mutual. And it's rarely mutual. I beg to keep my relationship because I grew up without a father. I know it's a lot. If you have any questions, I'd be very happy to answer them.
Thank you very much for your testimony, Mr. Tangway. Are there any questions for Mr. Tangway?
Thank you.
Seeing none? Thank you.
RSA 546A.
I
Thank you.
got it right here. A5. Okay, next, we're going to hear from Bill Woodbury. Mr. Woodbury?
Okay.
Yep, we're good.
One more time.
One more time. There you go.
Sorry about that. Good afternoon. My name is Bill Woodbury, and I am a practicing attorney in Laconia, New Hampshire. At least half of my practice is family law and has been for about 20 years. I am also the legislative chair for New Hampshire Association for Justice. We do support this bill in that we believe that it is the product of lengthy and thoughtful discussion, which I had the privilege of participating in at times. And it addresses a difficult problem that has come up repeatedly over the years, and that's when there is equal parenting time, but income parity or income disparity. How is that addressed in the child support calculation? And I believe that the fact that this bill lays out a schedule whereby numerous situations are addressed, but with rebuttable presumptions that allow the other side to make an argument if there's to be a deviation or no deviation. I represent both sides of this issue on a regular basis. And I think that, one of the concerns that I had personally, is that you could have a situation where you have equal parenting time, 50-50 split of parenting time, and you have a nearly equal income. But the expense profile on one side might be vastly different than the other. One spouse after divorce could move in with a parent, not have a mortgage, not have any student loans, and the other spouse could have all of those things. And so I think this bill begins to address situations like that, allows for there to be argument by an individual who believes that a deviation is warranted. I do believe that this bill is the product of a lot of thoughtful discussion. That said, if there are any questions from the committee, I'd be happy to address them.
Thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you very much.
Thank you, Madam Chair.
The chair will call Katrina Heinrich. Good afternoon, Ms. Heinrich.
Good afternoon. Hello, everyone. My name is Katrina Heinrich, and I want to kind of emphasize that I'm neutral on this bill for a variety of reasons.
Thank you.
But I don't think that we're addressing some underlying issues with it, which is truly how we interpret the best interest of the children. There's no provisions in this legislation that mandates the family court apply or be accountable to 1564 and act in the best interest of the children, even though it's in there. When we look at Section 458 of the U.S. Code 42658A, and you go to 169C2, the best interest of the child rules all court proceedings. And we all make that assumption. But due to the complaints and due to the issues that continue, we know there's something amiss. And I feel like that if 1564 language could be enforced, the 169C2 best interest of the child and the 50-50 scenarios to finances and parenting would positively impact timely and fair case management to all, ending a large portion of protracted case practices. The trade-off, when you dig down into it and dive deep, is that there would be some significant financial loss to the state from Title IV money. When I also look at parenting schedules, New Hampshire Section 458C5H1, as written, appears to highlight that the state's intent to meet the Title IV financial incentive requirements could impact this bill as well, because it speaks to equal and approximately equal parenting residential responsibilities in and of itself shall not eliminate the need for child support. Now, there are cases that absolutely could be true because there's a discrepancy in income. But it also shall not by itself constitute a ground for any adjustments. With that in place, I think the bill misses some pieces. I think we need to continue to dive a little deeper in who and how this is being interpreted and applied to the best interest of the children standards, considering there's some blurred visions of the business partners. More importantly, I think we're kind of missing the fact that some of these conversations have happened because there's been forced consent scenarios for child support orders. And they interfere sometimes in these, what I would consider private cases, because these are not cases on a civil or criminal docket. And I'm going to give you a couple of examples. The best interest of the children in an imminent danger situation, and I can speak to this myself from my own case. If you go to section 458 of the 42 U.S. Code 658, 169C3, the definitions, on 15, it says imminent danger means circumstances or surroundings causing immediate peril or risk to the child's health or life. But the family court's application of ex partes, they tell a completely different story. They often fail to establish imminent harm and danger, but strategically, and this was something that was brought up in testimony in Children and Family, which was that strategic filings on Fridays by attorneys, guardian ad litems, or even the other litigant becomes a very effective tool in interfering with scheduled weekend visitations. And if they do that enough and repeat it, it then starts that procrastination that we're talking about, and we're going to protract it out. The 170C5 says grounds for termination of parental and child relationship. And then we have the New Hampshire RSA of 461A6, which is determination of parental rights and responsibilities. Again, the word's best interest is there. But without due process actually being applied and absent from the bill, the family court will continue to simulate termination, causing harm to the family, but yet it's fulfilling a requirement of Title IV-D for absent parents. So in summary of this, I still believe that the bill has some legs in it. I do think that we need to look at what the family court is actually functioning on, what drives it. We know Title IV is a huge piece of it. And I think we need to adhere to some better principles in law. With that said, I would say we have to look at by whom, why, and how is the best interest of the child standard being applied when considering the financial interests at stake. While HB 1564 has merits, any laws passed by the legislature intended to create relief or maintain a more humane outcome for the families will be too easily circumnavigated by the family court. I will come back to say that perhaps the best event we could do is to close the family court organization as is and remove the financial incentives and immunity, just remove them. That way, every bill that's passed right now is being worked around by law. And I'd rather see it appear to actually work in the best interest of the families and children versus the stakeholders. Thank you.
Okay, thank you very much for your testimony. Are there any questions from the committee, from Ms. Heinrich? Okay, seeing
Your
none,
committee keeps getting smaller.
it's crossover, and
Yeah,
we have bills that are over in the House, so people have to leave. So, thank you very much for your testimony, Ms. Heinrich. Okay, the chair will call Rebecca Hutchins. Good afternoon, Ms. Hutchins.
Thank you so much for having me. Senator Carson and members of the Judiciary Committee, my name is Rebecca Hutchins.
Thank you.
I'm from Dover, New Hampshire, a mom of two. While I do not support 1564 in its current form, I do believe that it could be amended to be a small step in the right direction for child support changes in our state.
Thank you.
I support two specific aspects of this bill, increasing the self-support reserve, and also I support the possibility that a $0 order could be appropriate in specific instances. Every 4 years, the state pays for the review of the child support guidelines. New Hampshire's guideline review, it's quite large. Bureau of Child Support Services contracts this out, and it's conducted by researchers, economists, and social scientists. This study has specifically emphasized this particular one that came out in 2022, specifically emphasizes that New Hampshire is only one of 9 states that does not include a parenting time adjustment in its support calculation. And additionally, that this is one of the main reasons that our deviation rate is 48%. It's very high for our state. Deviations occur when child support guidelines are not followed and a different support order is determined. The latest New Hampshire support study, as well as those for the last 20 years, have recommended changing our formula to include a parenting time adjustment to reduce the number of deviations. According to BCSS, HB 1564 in previous testimony in its current state would likely increase deviations and add a lot of confusion. HB 1564 does not provide a formulaic parenting time adjustment as recommended by the studies, but instead includes a rule of thumb for deviations for a very narrow instance of equally or approximately equal parenting time if and only if parents agree to 50% of the add-on costs for their children. However, in proposing this mechanism to give a very narrow group additional possibility for deviations, the bill has repealed, perhaps inadvertently, the existing deviation provisions that many families rely on to possibly reduce their child support payment and share specific costs of raising their children. This was not specifically discussed in the Child and Family Law Committee, yet it needs to be addressed before this bill moves forward. HB 1564, page 1, line 25 through page 2, line 24, replaces a very key section of law, RSA 458C5, adjustments to the application of guidelines under special circumstances. Specifically, C5H, where parents who have shared parenting are able to ask the court to grant deviations in a very specific way. Removing this clear language and direction to the court and families on how to navigate deviations is further damaging, as the last line of RSA 458C5 requires that the party relying on the provisions of this section of law demonstrate special circumstances by a preponderance of evidence. So how is one to provide a preponderance of evidence when all possibilities of evidence have been removed from the statute? This needs to be preserved and reinstated. I've personally navigated my own deviations using this section of law. I have studied the statute and paid attention to how my attorneys have also navigated it. This bill doesn't include any way for me to litigate and for families to navigate deviations if they don't split all add-on costs. Our family court system is already short-staffed and under scrutiny for not giving consistent child support orders. How are we to navigate deviations now when the precedent case law for deviations would become obsolete, thus further hurting our families and the New Hampshire court reputation? I've included a methodology for possibly amending 1564. This would reinsert much of the language from RSA 458C5 that I noted was taken out, while including the language recommended in HB 1564. I would love to further discuss it. I've included a separate page that shows what I would recommend we do for the amendment. It really doesn't make any changes to what is the suggested language of 1564, but instead it allows it to be an add-on into 458C5H as an additional number. And so I'm recommending that we keep H1 intact, equal and approximately equal parenting residential responsibilities in and of itself shall not eliminate the need for child support and shall not by itself constitute ground for an adjustment. There's nothing wrong with keeping that in. It's not against what HB 1564 is trying to do, as far as I understand it. Additionally, the only other section of RSA 458C5H that I would recommend removing would be 2A. In cases of equal or approximately equal residential responsibility. The reason for that is that it gives you a little wider range, as does HB 1564, to understand that there are more parenting time situations than just equal. And our parents have very specific things that they can ask the court for. So this section of A really identifies what's included on how I can ask for a deviation. But HB 1564 strips that. So even though it says that deviations are possible, it doesn't tell me how to ask for them or what evidence would be possible in court. So I really would recommend a small amendment to HB 1564 that doesn't change what it's trying to do, but rather ensures that we don't eliminate parts of the law that people rely on.
Okay, thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you very much. Okay, the chair will call Marissa Chase. Good afternoon, Ms. Chase.
Good afternoon, Madam Chair. Thank you for the opportunity to testify today. For the record, my name is Marissa Chase. I'm the Executive Director for the New Hampshire Association for Justice, which is a statewide professional association of trial attorneys. We are here today in support of House Bill 1564. I believe that you will all recall there was a child support working group that was convened by the late Honey Hastings a few years ago that included mediators like Anthony Matramulo, who has, I believe, sent an email to the committee in support. That included attorneys from New Hampshire Legal Aid, which services low-income families, and perspectives from our association as well. So this group really covered the gamut of experiences in family court. Representative Katab reached out to us over the summer with the tenacity that she always does in trying to fix this piece of the child support in our family courts, and we had many discussions, ran through many different scenarios of how this would be applied and to who this would be applied, and we believe that this is a small step but a very important one, and I just want to thank her for all the work that she put into this, and we are in agreement that this is a problem worth solving.
Okay, thank you very much for your testimony. Are there any questions? Seeing none, thank you.
Thank you.
Okay, are there any other members of the public who would like to speak to House Bill 1564? Very quickly, Mr. Tangway.
Thank you. In regards to Katrina's testimony, she mentioned something that's very important where there is a $0 for the state of ordering child support and how it will affect the state budgets. So to counteract that, I forgot to say that RSA 546 will generate child support and help balance the budget properly, where some parties won't have some parties will have more assets. So the person who has the home, and that's very important. That's why I reiterate 546. Thank you.
Okay, thank you very much. Okay, again, are there any other members of the public that would like to speak to House Bill 1564? Okay, seeing none, we're going to close the public hearing. Thank you, Matthew. Thank you. Okay. We're going to go ahead and open the public hearing on House Bill 1573 and recognize the prime sponsor, Representative Pearson. Looks like we're playing kind of like tag today.
I have no idea
I'm in
who's
your
running my
and
committee
you're
over there.
here Now, and you're in this one. Just for the public's knowledge, Representative Pearson chairs the Children and Family Law Committee in the House.
Thank you, Senator. 1573 came out of the impetus to revisit how we place children in the light of the scandal at the Bledsoe Center in Tennessee almost a year ago. I spent about 3.5 months working with prime leaders in the Office of Child Advocate and also at DHHS to come up with some policy suggestions. And my committee sent out unanimously a bill with lots of policy language because, to their credit, the department wanted our guidance. And as legislators, we were only too happy to provide it. Along the way, a lot of that was taken out. A lot of that language was taken out by House Finance. That really didn't matter terribly for two reasons. Number one, there are other bills floating around, including a few from this body, that have that good language in it. And second reason is the process of working on the language motivated the department to start implementing a lot of these things already. So although 1573 exists before you is much slimmer, I, as the prime sponsor, do not worry about that. However, I would suggest to this committee that you be cautious in admitting lengthy amendments that seek to put lots of minute detail back in. And the reason for that is, frankly, our committee looked at a couple of possibilities on a couple of issues and very much went one way. The amendment that might be suggested to you actually goes quite the other way, and it would be out of keeping with what my committee unanimously concluded and DHHS concluded with us. So I would suggest, please, that you take 1573 in its latest form, accept it, we'll take the money, and they're doing the good work. And I'd be happy to entertain any questions while I catch my breath and go back to my committee.
Thank you very much for your testimony. Are there any questions?
Thank you.
Seeing none, thank you.
I'll see you soon.
Okay, the chair is going to call Cassandra Sanchez. Did she stay? Yes, Mr. Cuning.
So, they all have to be in Children and Family Law too, 417.
Okay.
So they're over there.
Do you want to come up? Did she give you,
I will try to do my best.
okay.
Hi, I'm Keith Kinning. I'm the advocacy director at Waypoint. As I said, we had a team of people working on these two bills, and the same, basically on Senator Carson and Senator Whitley's bill is happening at the same time. My team abandoned me and said, you go in, so they left me pinch hit, but I don't have a bat. So I'm gonna try to do my best here. Basically what we wanna say is that we initially supported 1573, but when it came through House Finance, there's just too many things that have been replaced and taken out. The main one is the $1 million that doesn't really have any specific idea of what they want to use the money for. I've been told that we'd want to put back in the certification requirements that would look at requirements, reporting, and enforcement. They also mentioned that in the findings, there is a statement that says that the commissioner cannot put someone outside of New England without the DCYF director approval. That needs to be codified in 169F. So basically, the bill as written is not something that we can really support at this time. And we'd like to see it go back to more of its original form or be closer to the current bill that's being heard currently up in Children and Family Law, which is SB 417.
Thank you very much for your testimony. Are there any questions? Mr. Kuning, I have a question. I have
Yes.
a couple questions. It seems like one of the big differences between this and Senate Bill 417 is this $1 million. We first heard about it Friday. We discussed the bill in the Oversight of Children's Services Committee, and I was surprised that they just gave $1 million but said, here, you can do with it whatever you want, that it's not entailed or directed towards anything in particular. Am I right in that assumption?
Yeah, it says right here, the sum of $1 million is hereby appropriated to the Department of Health and Human Services for the purpose of enhancing oversight of residential facilities. We would like to see more, specific
Correct.
reasons why that money's there. I was not at House Finance that day, but I think this is one of our biggest concerns is that if the department's going to be handed $1 million, we'd like to see what that money is actually going to be used for. I think people have to remember that both of these bills came out of the Bledsoe. What happened there, that children were found down there. They were being kept in an area of razor wire. They were in, my understanding was they were in prison uniforms. They were made to sleep on the floor. And there just needs to be more oversight about what's happening as these kids are being placed out of the state. So I'm hoping we learn the lessons of Bledsoe, which is these are our children. These are New Hampshire's children. For them to be placed, let's say if you live up in Claremont or someplace north, maybe being placed someplace in Vermont makes more sense for the family. But I think what we're trying to do is keep as many of these kids as close to home as possible. We want them to be near their families. We want them to be near their friends. If there's something specific that we don't have in the state or in the region, that they need a specific kind of residential care that we can't provide, then okay, that makes sense. But the other times the children should be kept as close to home as possible.
Okay, thank you very much for answering my question. Are
Thank
there
you.
any other questions? No?
All right.
Thank you. Okay, the chair will call Robert Tangway.
Thank you, Robert Tangway here. I am opposed to this bill. There's something I want to draw attention to the Senate. And we have repealed the dividends tax. That equates to about $136 million a year. It was pushed right through, which extends beyond the entire judiciary's budget of about $109, maybe $112 million a year. So we need to really have more oversight. But these orders for where the children's placement are all court orders. And it says in this bill, we're giving out $1 million to the DHHS without really any specifics on how to do it, how to use it. And then you're saying you need more judges, but we repealed very quickly interest and dividends tax, which, by the way, Justice Hans Marconi of the Supreme Court's husband has a financial disclosure where he has pecuniary interest in where he would make more money off of the dissolution of the interest and dividends tax. That was disclosed too. So you can look that up at the Secretary of State. And then in conjunction with that, we also passed a law which is quite peculiar, which gives the Supreme Court, this is all within the last year, the Supreme Court the ability to handle the financial disclosures by the judges. So now are those financial disclosures not going to be on the Secretary of State's website? Are they going to be hidden in the catacombs of the Supreme Court? What we really have here in the state of New Hampshire and across the country, but specifically in the small, powerful state of New Hampshire, is we have a judiciary, which the three branches of government, the judiciary is this real big triangle, and it has more power. They can choose anything, including what happens to your children. So if I was to happen to sue the state and get $1 million, it doesn't matter because the family courts still have unlimited discretion. And then when they violate the laws that we enact, cause fraud, they send you up to the Supreme Court, which is now violating, I contend, federal rules of civil procedure. So we're just not able to get justice. So while I do want these poor kids who have gotten the unfair shake at life, they didn't ask for any of this. It really starts in the court and making sure that the facts are correct in the court. Because my biggest fear is, since the mother's not that horrible, though I contend she's abusing my children, is my children being put into placement. So I would rather me suffer than my children suffer. That's the biggest fear. Like, just imagine not living with your parents, what that does to a child. So with that being said, I don't find this expedient. I think that we need to really focus on the family courts, making sure that the judges are telling the truth, the lawyers are telling the truth according to the 0311:6, and that there is not retaliation against pro se litigants, which has happened in many cases. Thank you so much.
Thank you very much for your testimony. Are there any questions for Mr. Tangway?
Thank you.
Seeing none, thank you very much. Okay, are there any other members of the public that would like to speak to House Bill 1573? Hi. Oh, I know if needed, you came. Okay. Yes, but she's not here, and Mr. Kuning said he was speaking for her. Okay, all right, let's. Yes, I know. Please have a seat, Ms. Marcio.
Good afternoon. Sorry for the confusion. Lissa Mascio, the Associate Child Advocate with the state of New Hampshire. We are here to testify on 1573. At this point, we are only in partial support of the bill that we had originally written because all of the policy has been stripped out of it, and it is now rather a blank check to DHHS for $1 million with no policy attached to it. Representative Wallner did add a floor amendment with at least some reporting capacity, but in our eyes, handing DHHS $1 million with none of the important policy is simply not something we can support. As you all know, this was originally drafted in response to the OCA's visit to the Bledsoe Academy last July and our work with the Oversight Commission, and both Senator Whitley and Senator Carson and Representative Pearson on this bill all were working towards an end to protect these children. So as you know, at Bledsoe, we went to visit 2 New Hampshire children that were allegedly in a level 3 therapeutic facility. And instead, we found a youth detention center with barbed wires, cameras everywhere, children in jumpsuits. So the original HB 1573 had 3 distinct parts. The first part was around the certification process held at BCBH, which is currently in administrative rules. However, we found based on our investigation and further conversations that a lot of those rules weren't being followed. Facilities out of state were being certified without actually ever being visited in person. They weren't getting the annual visits that are required under administrative rule, and they were in fact being recertified without visits. They were only all being done remotely. So in the case of Bledsoe, it had just been recertified a month before the OCA visited, again, without an in-person visit to see that children were sleeping on mattresses on the floor, that the facility itself was on a provisional license due to fire code violations, and that the children were being horribly mistreated. So that first section of HB 1573 was around certification, creating a specific team at BCBH with very specific parameters around those visits, enhanced enforcement, and enhanced visits going from once a year. Originally, it was 4 times a year, but through the process came down to twice a year, at least once unannounced. The other parts of the bill, the second part was around DCYF monthly visits. That part is now in SB 417, as you know, that passed through the Senate. We
are fine with the way it is in 417. We worked very hard on that language with DHHS to make it a reasonable process for staff and to protect children. And then the third part was a very lengthy judicial oversight piece. That also was attached to SB 417, again, with language that the OCA worked very closely with DHHS as well as the judicial branch to come to a reasonable compromise about enhancing protections for children without completely overwhelming the judiciary or DCYF. As I said, as it stands now, this bill has been stripped of all policy. Essentially, in the House, it was expressed that the department and BCBH was already addressing all of the issues at Bledsoe, so this legislation was not necessary. At the same time, though, the department also claimed that in order to comply with the legislation, BCBH would need to double its staff from 8 to 16, and they would need over $1.6 million in the next year for staffing and travel. But they said they didn't actually need the bill because they were already doing everything in it. So that was confusing, but the claim that they were already doing everything in prevailed, and so the bill that passed the House floor in February 22nd ended up just really being a statement of findings and $1 million. So we continue to have grave concerns about that certification process. In the last month, the number of children placed out of state under CPS has gone from 2 children to 7 children in 1 month. And we know that there are a couple more very far away under BCBH placement. So the idea that children weren't going to be placed far away is apparently not being done without new law in place. In addition, the OCA has asked repeatedly, both formally and informally, for data, for reports, for a list of the visits that have been done, for a list of the upcoming visits, in order to see whether changes really were being made. We know that a member of BCBH has been visiting facilities since Bledsoe occurred, quite a few of them, including a number of new certifications in Oklahoma, Virginia, Arkansas. We've asked for all of those reports and site visits. Just last week, we got a thumb drive that had some information on it, although it appears to only be in-state or local placement visits. We didn't see any of the out-of-state facilities that we're aware there are children at now under newly certified placement, and that's the data we were looking for. So we continue to have grave concerns about this certification process, how stringent it is, whether the children are truly in safe places, and why children are still being sent so far away. Why are we certifying a number of new facilities thousands of miles away when we all say that we're working towards this end goal to get children back in New Hampshire or local within New England? So we would propose that this committee consider amending this bill to reinstate the sections relating to certification. We do have concerns with the original ask of $1.6 million. We think that's a vast overreach for what needs to be done, especially with the amendments that were made of only 2 visits a year. So we believe that even putting in that whole section on certification, the $1 million already allocated by the House should be way more than enough to do what needs to be done just in that section of the law. So we are in the unfortunate position of having to say that our bill as it currently stands is not good law, does not protect children, really does nothing to move the ball forward at all with all of the things that we've talked about. So we would ask this committee to consider amendment. We're happy to help work on that language to get that bill at least partially put back together with just that certification piece, since the monthly visits and the judicial oversight is already in SB 417. I'm happy to take any questions.
Okay, thank you very much for your testimony. Are there any questions? Thank you.
Thank you so much.
Okay, the chair will call Krista Morris.
Good afternoon. My name is Krista Morris. I'm the Director of Intergovernmental Affairs with DHHS. And I just want to start off by saying we appreciate the opportunity to speak to this bill as it stands. HB 1573 provides the department $1 million, not as necessarily a blank check. There are parameters saying, it is to review and look at the policies and procedures within the department regarding out-of-state residential placement. That is the anticipated or the intent of that bill. And so we would stick to that intent of looking at our policies, procedures, and possible statutes that would need to be addressed in order to bolster that program. So a number of things regarding, I guess, the proposed amendment by the OCA, to bring back in the certification piece. We just learned about that amendment today. So I'm trying to piece together some of that. And it does bring back, yes, the certification team. The reason for the fiscal note that would be attached to a certification team, yes, we are doing the 1 visit per year as in current law or current rule. The original intent was bringing it up to 4 visits per year. That's why that was such a large fiscal note. Then as it brought it down to 2 visits per year, it dropped it to under $1 million for the certification piece, or they're about $1 million. I'm pulling it up now. So that includes the travel costs, the team that would have to be established because it's establishing a separate team to go do these certifications, and things of that nature. So we just want to make sure that it's understood that we don't throw fiscal notes together without intent, and we do go through them carefully. So we did provide information as a spreadsheet to the fiscal committee on the House side when it pertained to that amendment. I guess really I'm here for any questions. I can't speak to the other items, such as the number of youth being placed out of region going up. I'm not a subject matter expert. I'm not in that directly, so I can't speak to that other than sometimes our staff has to do what's needed for the best interests of the child if the services are not closer to home.
Okay, thank you very much. Are there any questions? I have a quick question because I was listening very carefully to what you had to say about the $1 million.
Mhm.
And are you telling me that it's going to take $1 million to review our existing policies?
It wouldn't be just to review. It would actually start to implement some of the changes that we would see needed. I can't tell you specifically what that would be as to, whether it's a new system in place so that we can get data to the OCA in a faster manner. I couldn't tell you if it's to maybe look at or try out new systems for certification, new systems for the monthly visits that they discuss for DCYF. But those would all be addressed and looked at. And then if we felt that we needed to pilot those programs, we would have the funds available to do that so that we could then come back and say, we need this in rule, we need this. We want to be able to try it out before putting it in rule or policy or statute, so that way we know what we put forward will be effective.
Okay. Just a suggestion. If you can have the department put together as much detail as you possibly can about where that $1 million is going to be spent and how it's going to be spent, I think would be very helpful. I'm just going to leave that here.
Sure.
Okay. Okay. Are there any further questions? Seeing none, thank you.
Thank you.
Okay, are there any other members of the public that would like to speak to House Bill 1573? Okay, seeing none, I'm going to close the public hearing. going to go ahead and open the public hearing on House Bill 1588 and recognize the prime sponsor, Representative Long. It's good to see you again, Representative.
Honorable members of the committee, I'm Representative Pat Long, representing Hillsborough District 23 in Manchester. House Bill 1588 is intended to amend the Juvenile Justice Statute RSA 169B, C, and D to align with the new upper age limits for special education. Juvenile justice laws allows the juvenile court to retain jurisdictions of a child beyond the 18th birthday with provisions. Students involved in juvenile court cases often qualify for special education and often require a court-ordered residential placement for purely non-educational reasons. In recently amending our special education statutes, RSA 186C, from 21 years of age to 22 years of age, we overlooked RSA 169B, C, and D. House Bill 1588 allows a juvenile court to retain jurisdiction until the student ages out of special education at 22. I thank you for your consideration, and I look for your favorable support.
Thank you very much, Representative. Are there any questions? Seeing none, thank
you.
you. The chair will call Robert Tangway.
Thank you, Madam Chair, and distinguished members of the Senate. My name is Robert Tangway. I am the author of New Hampshire Oliver Twist. And this bill, which I oppose, reminds me of New Hampshire, or, well, Oliver Twist, and orphanages and children being taken away from their families and used. I mean, basically, you won't see rich people's children getting taken away. It's only the poor. That's the way it's been since the beginning of time. This bill gives, and it is a bill, because there's a $3 million price tag, number 5, given to the Department of Health and Human Services to retain jurisdiction over children, which are, I guess, special needs. And I just don't think there's any reason for this. Now, I want jurisdiction over my children, whether they have special needs or not, because it's my God-given right. A parent would be needed to be incarcerated to be removed of their rights according to the Constitution, which would mean criminal charges, or they would have to submit to a plea. They would have to be judged by the jury of their peers or submitted to a plea. We need to fix our family courts. This is akin to political patronage, which is not allowed by Title 4D. The state is supposed to, including Matt Hayes, who spoke earlier, and I'm not angry at any of you guys or anybody, I'm just trying to be focused. The state is required, and I will send these laws to you, I've written them down, to create a system to find out fraud and political patronage. Because that's what we have. Our justice system, as much as we try to make it perfect, is based on our biases, inherent political patronage. And that's what these laws are. And we try our best. But it all comes down to, there's a contract which I'm going to send you guys. It's called the Expedited Child Support Program. It was signed a couple years ago to expedite the granting of child support, and has promulgated to all parenting cases. They want to issue child support immediately. Within 6 months, 75% of all child support orders, and within 1 year, 90%. That's their guidelines. This is from, I believe, the Department of Justice to, and it's signed, to the AOC, to the family courts.
Mr. Tangway, this bill is about extending court jurisdictions over persons receiving special education. It has nothing to do with child support or anything like that. So I'm wondering if perhaps you've got some bills maybe mixed up a little bit.
Senator Carson, I appreciate that. I don't. It's all connected. You have to look at this as a big scheme. The court retains jurisdiction and it's connected so that they can connect child support and get money from Title 4D, federal money. So they're asking for more money and they're taking jurisdiction. I don't want them to have jurisdiction over my children or anybody's children unless the person's incarcerated. So this bill for $3 million also grants within the law jurisdiction to the state stolen from a parent who's then required to spend money on child support to the other parent, tax-free money, which then the state can go and ask for more money from the federal government,
Okay.
which we're all paying taxes on. It's hidden taxation. So that's the point I want to make. So in conjunction with the earlier bill that I said, I don't agree with that. Inexpedient. This one, inexpedient. They have the money. They need to look at the fraud that's in the courts. And for instance, the mother of my children's working part-time. She owns her house, most of it. She has far more assets, yet she is collecting government assistance. Her mortgage is less than my rent. And this is not just me. This is many families, mostly men, but then women, when they're less politically connected, or, and I've been working on this for a while, when they don't act like a woman is supposed to, which is docile, subservient. And when a man does not act dutiful like they're supposed to, they get penalized. And then if they don't have lawyers, that's how that works. So again, thank you so much.
Thank
If
you.
there's any questions.
Thank you, Mr. Tangway. You had checked that you were neutral on this. Would you like me to change that to opposed?
Yes, Senator Carson.
Okay,
Thank you.
all right. Okay, are there any questions for Mr. Tangway? Seeing none, thank you very much. Are there any other members of the public that would like to speak to House Bill 1588? Okay, seeing none, we're going to close the public hearing.
Happy to. Thank you, Mr. Chairman. Representative Tim McGew for the House, introducing House Bill 1589, establishing a Veterans Treatment Court. Thank you for your consideration and happy to introduce the bill. Thanks.
Good afternoon. Thank you for letting me speak on this. I'm for this bill. I'm not 100% sure. I actually have some questions for the committee. Okay. Well, it's not, my testimony is that I can't find RSA 490I 1, which is being repealed by this bill. My testimony is in regards to the family courts and the treatment of veterans. This is nationwide, but also in New Hampshire. Obviously, if you're a veteran, we wouldn't have these freedoms if there weren't veterans. What this bill appears to do is create a special court for veterans, given that consideration. I do have some concerns, whereas that maybe if you're a veteran, your ego, but I've talked to most veterans, they realize that they are not better than us. They get special licenses, but they don't have any extra rights than us. So I haven't fully evaluated this bill. However, from my understanding is it's creating a special court for veterans. And I would like to see that because I know a lot of veterans who get used, they have PTSD, and then the other party will say, I'm afraid of them to get a strategic advantage in the family court. These are our veterans that fought for us, or at least risked their lives, or at least made themselves uncomfortable, sweating in a desert somewhere to make sure we can live our way of life. And to put back PTSD, which is able to be handled, and hold it against them, or not acknowledge why, and take away rights in the family court specific, which is my main concern, because that you really don't get a fair shake in family courts. I think that it is a good idea. I haven't evaluated this bill completely, but I think by the sponsors and just reading through it briefly, I think it's a good idea. It's something that we should look at and move forward with. If there's any,
Do you want me to switch it to support from neutral?
yes,
Okay.
I read through it. Thank you.
Do you have any questions? Seeing none, thank you for your
Thank you. God
testimony.
bless.
Julie O'Neill.
Here we go. Good afternoon. My name is Jill O'Neill. I was part of establishing the first Veterans Treatment Court here in New Hampshire in the Nashua Circuit Court. That was back in 2014, and I've remained involved in supporting the establishment and the growing of veteran treatment courts throughout the state. I served as the facilitator of the New Hampshire Justice Involved Veterans Task Force. What I saw over the course of from 2014 to present, we've seen good success with veterans served throughout our courts here in New Hampshire. We're following, these are tracks off an existing mental health or drug court, so we're incorporating the essential elements of implementing a veterans treatment court. We were actually recognized nationally as a model, as a best practice model for serving those that were both VA and non-VA eligible. We had a safety net of catching veterans who were experiencing service-related psychological injuries, and some folks that were discharged under honorable, we were able to capture them in the safety net and serve them through the treatment court program. We had an 89% completion rate, so recidivism we were not able to measure, and really where we fell short and where we fall short as a state is having governance, having ownership of somebody that's in charge of these programs. To help counties establish that have not yet established a veterans treatment court, establish them. There's no intentional referral process for veterans to be sure that if they were considered to be eligible, that they would be screened. So we have folks that are unfortunately falling through the cracks for a program that works highly effectively. So I'm here in support of House Bill 1589 with the amendments proposed. And I cannot echo being somebody that's volunteered since 2014 to collect data, just as a volunteer, just to make sure that that narrative carried forward of the importance of these programs. And the data is critical to this because it helps us formulate treatment programs. Example, case in point, we saw a lot of substance misuse and domestic violence, simple assaults, right? So we worked with the VA to ensure that there was adequate program, care supports, et cetera. We saw a growing number of negligent discharge of firearms. So we want to make sure that it's not only about do these programs work, but it's in alignment with our stakeholders in the community that are providing treatment to assure that we understand what's going on and we can reduce and address treatment needs and also reduce criminogenic risk factors. So it's very critical that we have some ownership, and that the built-in of the coordinator to these programs is essential for these programs to not only be successful, but also, again, for counties to establish these programs to ensure that no one's falling through the cracks. Thank you.
Thank you very much for your testimony. Are there any questions?
Thank you very much.
Seeing none, thank you. The chair will call Erin Cregan. I think she left. Okay. The chair will call Jane Graham.
Good afternoon, Madam Chair, members of the committee. Thank you for taking my testimony. My name is Jane Graham. I'm the Strategic Communications Administrator for the New Hampshire Department of Corrections. The Department of Corrections is very supportive of treatment court tracks. We have a lot of experience with the drug court track. At this point, we would just like to have it kept in mind as this bill progresses through the Senate that we will need some additional resources. In our original fiscal note, we did add one probation parole officer for each of our district offices. When we worked through some of the numbers with the House Finance Committee, one of the numbers that was thrown out was that the estimate for the amount of veterans taking part in this track statewide would be about 40 per year. If that holds true, we could potentially do a rolling number of added probation parole officers rather than just immediately right out of the gate adding one per office. However, specialty courts take a lot more of a probation parole officer's time than a regular supervisee will. And best practices within corrections stipulate that caseloads for probation parole officers who are working within specialty court tracks should be kept under 50, while the majority of our probation parole officers supervising non-specialty court supervisees will keep a caseload of well above 50. So we will need extra resources, and we could potentially have an officer or two that travel throughout the state to oversee these caseloads, but we will need some additional resources. Thank you.
Thank you very much for your testimony, Ms. Graham. Are there any questions? Senator Chandler.
Thank you, Madam Chair. Ms. Graham, can you just give me a little bit of an idea about why a specialty track parole and probation officers, they need more time?
The specialty court tracks tend, and I can get you some more information from our experts that are the actual officers, but they have more team meetings, more clinical assessment, more planning to try to keep folks out of the justice system and staying on the right track. So they do require more resources. Thank you.
Are there any further questions from the committee? Seeing none, thank you very much, Ms. Graham. The chair will call Warren Perry. Good afternoon, Mr. Perry.
Good afternoon, Madam Chair, members of the committee. For the record, I'm Warren Perry. I'm the Deputy Adjutant General for New Hampshire's Department of Military Affairs and Veteran Services. The department is in support of this bill. We've had, as you heard from Ms. O'Neill, we've had experiences with having veteran tracks inside some of the alternative sentence treatment courts. They've been very successful. The demand in the court system is relatively low. In my testimony in front of the House, we anticipate if we kind of extrapolate from the 2018 numbers that we had, we can probably anticipate somewhere between 28 and 40 a year going into this track is what we anticipate coming into the track, with the most of those being probably in the Hillsborough and Rockingham systems. We think this is a good law because the alternative sentencing tracks and dockets in the courts, they cost less, even though there'll be some additional resources that will be moved out of what is in the prison system to probation officers and people that are doing case management and managing these programs. So we have successful graduation. It's still less than incarcerating people. So that's the first thing. We don't think it's a huge additional pull on the state. Less than 60 a year for sure. Probably closer to 30 a year in this system that would be able to take advantage of this. So we just think it's good business to adopt these kind of these systems. The one thing I would ask you to look carefully at, and I'm not going to, we like the bill, right? So we like the bill. One thing I would ask you to look very, very carefully at is on page 3, lines 12 through 16, the definition of veteran. And in those lines, there are things that we would not traditionally call a veteran in the state, as the definition of veteran gets convoluted. So, I think that definition in lines 12 through 16 warrants your careful consideration. So subject to any questions you have, that concludes my testimony. And Representative Lynn did ask me also, I know he asked you to say that if you had any questions or anything specific, technical questions about the legal system, he's happy to answer them. He just had to run to another hearing. Again, subject to your questions.
Okay, thank you very much for your testimony. Are there any questions? Mr. Perry, why? Because I'm looking at this under the definition of veteran, and I'm glad you brought this up. You're talking about contractors, current or former contractor for the United States Department of Defense who served in a theater of armed conflict, or a current or former military member of a foreign allied country who was attached to or under the command of the United States forces. Why were those included in the definition of veteran?
I think the spirit of those definitions were to protect people who may have immigrated, who may have been interpreters, may have worked directly with put their lives at risk in theaters of operation. I know I very, very much depended on my interpreters when I was deployed. They were an integral part of my team, and I would probably stop what I'm doing and go eat some nails or broken glass if they showed up here today. So I think that's the spirit of it. And there were a lot of other contractors that went to the theater of operation that supported our operations, in Iraq and Afghanistan, among other places. And I think that and I'm not going to speak for the sponsor or the drafter of the bill. I'm going to be careful not to do that. But after hearing the testimony in the House, they wanted to be inclusive of those people who also sacrificed for the country. My warning to you, I don't know if a warning is the right word, but the reason I bring it to your attention is because those individuals are generally not considered veterans. And if this is a veterans treatment court and we're defining them as veterans, I just want that to be a deliberate decision by the general court before they move this bill forward. I don't know if I've answered your question.
You sure did. Thank you. Okay, are there any further questions? Seeing none, thank you. The chair will call Aaron Cregan.
Good afternoon, Madam Chair, members of the committee. My name is Erin Cregan. I'm the General Counsel for the Judicial Branch. I appreciate the opportunity that the Judicial Branch had to consult with the prime sponsors on the bill. There is a currently existing veterans track in the law, which the court does implement in a few of our areas where we have identified that there are a few veterans that could take advantage, but it is not statewide. In many jurisdictions, there would only be either 0, 1, 2, maybe 3 people that would potentially be eligible. And so we've really only convened the track in areas where there are a larger population that we can bring into the system. And I think that the prime sponsors looked at that issue and saw that there was a way that we could potentially combine dockets or create virtual dockets or otherwise try to adapt to the challenge that we have, that the population is diffused throughout the state. And it is not incredibly large. It is probably a few dozen people. But it is helpful. The policy intention which undergirds the proposed bill, which is to formalize the Veterans Court more, is a helpful idea. We've talked with some of the judges who administer the veterans track in some of the different courts, and they would appreciate more legislative guidance. Whether you change some features of that formalization is something we would defer to you on, but it is helpful to have more guidance from the legislature on what is desired in the veterans courts, and it is helpful for it to be more resourced. One of the things that the prime sponsors envisioned, which potentially could be helpful in moving from a veterans track to veterans courts, is the creation of a coordinator position, which right now this is really a collateral duty for judges. There's not a dedicated staffer assigned. Having a coordinator, something that would certainly formalize the program more if that's the legislature's intention.
Thank you very much for your testimony, Ms. Cregan. Are there any questions? Seeing none, thank you very much.
Thank you, ma'am.
Are there any other members of the public who would like to speak on House Bill 1589? Okay, seeing none, we're going to close the public hearing.
Oh my gosh.
I saw that and I said, that's good. Last one. We're going to go ahead and open the public hearing on House Bill 1339, and the prime sponsor is not available, but Representative McGue is here to introduce the bill. Welcome to Senate Judiciary, Representative.
Thank you, Madam Chair, members of the committee. I'm Representative Tim McGue from Hillsborough County District 12, the town of Merrimack, one of the co-sponsors of House Bill 1339, which seeks to define and provide due process for return of an individual's property that has been confiscated as part of or surrendered as part of a domestic protective order. The bill provides for the courts to conduct a NICS check or National Instant Criminal Background check using the current system should one be required. After hearing witness testimony, it's the opinion of the House that this bill clarifies the due process provisions to return the individual's property following the temporary holding of firearms and ammunition for some legal reason. After hearing from the Department of Safety, the Domestic Violence Coalition, and the New Hampshire Police Officers Association, the bill was amended to meet several of their concerns with the process and establishes certain timelines for the court hearings to return the firearms and ammunition to their lawful owners once a motion has been filed in the court of jurisdiction. We believe it's in the best interest of the public for the government to return the individual's property in an expeditious fashion once there's no further legal prohibition. So the bill was amended to its current form by the House Criminal Justice and Public Safety and passed in a fully bipartisan fashion and eventually passed by the full body, including finance, and ultimately on consent by voice vote. So we thank you for considering it and considering it favorably. Happy to take any questions on that.
Thank you very much for your testimony. Are there any questions for the representative? Senator Gannon.
Thanks for listening to my question. And I haven't really read the book, which I will. Why is there a discretionary background check? Why isn't it just an automatic return?
Well, that's a very good question. And the sponsors and myself, we were wondering the same thing, which is part of the reason the bill came forward. And we consulted some legal counsel to help with the final drafting of this and consulted all the interested parties to refine the language from the original bill to clarify what was in law. So that's a good question. I guess over the years, it's been unclear exactly how and when to return an individual's property following the surrendering. It's been an issue, which is why we needed the bill.
I guess the word follow.
Yes,
it's
follow
just
up.
the word discretionary bothered me somehow. I'm going to read the bill more. It's my fault. I'm not as prepared as I should be on this bill. So it just little things picked up. I'll spend more time on it.
In line 14, you're talking about?
I'll pick up on it later. Don't worry.
Okay.
Yeah, that would be the word, yes.
Are there any further
Well,
questions?
I think what you're asking about is, so they don't have to order.
Yep.
And as I recall from testimony, the state police wanted a hook to hang their hat on. They wanted to be able to say that the court ordered it, or they had a court order. They were often asking, and I'm sure we'll hear from some officers behind me that I think are going to provide some insight on that. I think they'll be able
Sounds
to
good. Thank
answer
you.
that. Thanks.
Okay, thank you very much, Representative. The chair will call Captain Muzzy and Lieutenant Mary Vanille.
Thank you, Madam Chair, members of the committee. Thank you for having the state police here. I'm Captain Victor Muzzy, and I have Lieutenant Mary Bonilla here with me. I am the captain that oversees the Justice Information Bureau, which includes the gun line, and the lieutenant here oversees the gun line directly. And so I think first, Senator, to answer your question, not to speak on behalf of all departments, but certainly some, I think the theory is the guns were relinquished, if you will, to a department via a court order that says this person's got a restraining or stalking order. And it's been the practice of departments to return those by court order so that there is no discrepancy. And certainly we don't have an unauthorized person showing up at the door of a police department saying, hey, I'd like my guns back, without any sort of formalized process. So hopefully that answers the question relative to that a little bit better. The state police on this particular bill, I think, is neutral. We're here today before you, I think, to express our practical application and concerns that we have with Section 2B. And just to clarify some of this, oftentimes a gun check through our office is referred to as a NICS check. As everybody is probably familiar, the FBI for the state of New Hampshire does long gun checks. And oftentimes a NICS check kind of gets intermixed with the theory of a background check. And so what I mean by that is the FBI and all of its resources doesn't always have accessibility to all databases that maybe we do, namely state databases and things like that. So they rely very heavily on the NICS indices by which to make a determination about someone's suitability for the purchase of and/or return of a firearm, where our process gets referred to as a NICS check. And I guess the best analysis that I can use is kind of a silly, simple one, which is everyone calls them Kleenex, right? But they're really tissues. It's kind of similar, where everyone calls it a NICS check, which is certainly one of the indices that we at the gun line here in the state police check. But there's several other things that we're checking, like state criminal history records and other corroborating information. And that's important because not every disqualified person or disqualifying event ends up in the NICS indices for a laundry list of reasons. And so with that, when a check comes through our office, we have an obligation to check the NICS indices, which is part of that process. But we also look at, again, things like state criminal history records, which on its face may show a conviction for a simple assault. And while that offense on its face is not a disqualifying offense, it may very well be based upon the relationship that that person had to the victim in the case and things like that, which requires further research on our part. I can tell you that, as you can well imagine, we are at the mercy of other agencies, be that police agencies, courts of jurisdiction, both in-state and out-of-state, to provide us those corroborating documents in order to make that determination, in order to determine whether someone should be approved or denied, and that often takes time. And just because it's our priority, certainly in this state, it's not always the priority of the other state or the other agency or jurisdiction that we may be relying upon to provide us that information in order to make that educated determination and provide that back to the court in this case. And I say all that to say, again, on page 1, section 2B, lines, I think, 19 through 25, one thing of note, the first paragraph says the Department of Safety shall initiate a NICS check and shall provide a conclusive response to the court within 10 business days of either a proceed, basically, or a deny. And then you've got a follow-on sentence that's somewhat contradictory to that to say, if we can't determine that within 10 days, we've graciously been able to get this amended to say that the Department of Safety may provide a proceed letter. I think our concern is that any judge that gets a letter from the Department of Safety that says this person may proceed is probably going to rely on that because we've done the research for them, and that may not really be the case. And what I mean by that is it might be a maybe, and it might be a maybe for 10 days, 20 days, 30 days, or hopefully not much longer than that, but it might be a maybe because we have not got that supporting documentation back from whatever jurisdiction we may be relying upon to be able to read the narrative of the police report or the specific criminal complaints that allege what type of relationship it is. And so all we're really asking for is a more clear language to allow us to inform and educate the judge at whatever time frame is dictated by this bill or any successful legislation with whatever we might have. And if it's day 10, and we can say, Your Honor, we've got this amount of information at the moment and we can't make a determination, at least it allows us for that relief to be able to give the court of jurisdiction over this return of firearms issue, whatever information we do have. The fear here is that, or my thought here, our thought here is that this is really looking for us to lean towards a proceed. And again, I think, there needs to be some, and hopefully my explanation here provided some clarity around the NICS check, what that really means. It's more than just NICS for more than one reason, and not everything that's a deniable offense ends up in NICS, again, for various reasons. And so for those reasons, we have those concerns. Otherwise, the time frame, the mandated days in between and things, all neutral on that. That's fine. Our office is assisting with that process now. And again, it's a little unknown exactly how much traffic this will increase through our office, given the fact that this is a discretionary check, at least as written at the moment. We'd like to think, in order to keep up the level of customer service that we've got now with this in addition, that one additional resource would be okay for us in order to, again, to maintain that level of service. But those are really our concerns, just to be able to better articulate what our current process is and have this law or this proposed bill allow for that process effectively, and again, not to hold up the process by any stretch of the imagination, but to just be able to allow us to inform the judges of what information we do have when the hearing comes around. So I think that concludes what I have to say, Lieutenant, unless you have anything to add to that might be of value that I forgot.
Okay. Thank you very much. Are there any questions? I got a ton of questions here because I'm sitting here listening to this and I'm going, oh, what are we doing?
And so again, I think just to make it clear, I know the struggle from the sponsors of the bill, and that's that, again, if Vic Muzzy appears at the police station and says, hey, I want my guns back, the order was dropped yesterday, the department's going to say, well, wait a minute, who are you? And, so I understand that there is a need to have things happen in rapid succession so far as timeframes go because the reality of it is that same individual can call our gun line and buy a gun the next day, but can't get his own guns back, which seems a little bit counterintuitive. And so for those reasons, I understand the intent clearly of the legislation, and that makes perfect sense to me. It's just the practical application of what our office is responsible for that's want to at least educate the members of this committee, as we did with the Criminal Justice and Public Safety Committee in the House, on what the process is, just for awareness and to make the best decision we can.
One of the questions I had, and I wrote it down, does this do away with the court process? I don't think it does. I think it works together with that, because my understanding of this is someone comes and they make a complaint. It's ex parte, it's done immediately, and an order is issued, and the person is arrested or the guns are confiscated. And then they can request an expedited hearing, and they usually have one, I think, within 4 or 5 days. And at that point, the judge will look at all the testimony, people come in and testify. If the judge says, okay, this is warranted, they'll sign off on a domestic violence restraining order or stalking for a year. But if there's no findings, at that same time, the judge can issue an order to return the guns back to the individual because they've had a hearing, they've been found there was no substance to it. You can have your guns back. Is this another step that someone has to go through? Because I'm concerned about this idea that the court, in its own judgment, that they can request a NICS check, but there's nothing in here to say, okay, what is going to prompt that? There's, is the judge just going to say, this guy looks like a criminal, I'm going to do a NICS check? There has to be a reason in order to access the line. We were told the NICS line is private, all this information is not available. It just seems like it's being opened up for no reason other than it's a judge's discretion to take a look, but then there's no definition of what that discretion actually is.
When they're required to perform the check or request one.
Right, and I'm like, that's why I said I got a ton of questions here, because whether we agree about guns or not, it is a constitutional right, and our job is to protect our constitutional rights. So if someone has gone through this process, this court hearing, found not guilty, court orders, hey, 10 days, you get your guns back. Why do they have to even worry about going through a NICS check? They've gotten the guns, and I know why, because you want to look for a prohibited person. But what gives you the right to look to see if they are a prohibited person? If they've been found not guilty, what are you doing? Are you guys on a witch hunt or something? Are you trying to find people that maybe own guns that shouldn't own guns? I don't know. I'm really kind of confused here because I don't know what the purpose of this is, other than to keep guns out of the hands of people.
Well,
and somebody who's been found not guilty. So what's going on here?
Yeah, I can't speak for the sponsors of the bill, but my feeling on it is that they have issue, and probably rightfully so, with the timeframes by which the court is moving to get these things returned to the rightful owner. And I think this is the intent, was to set those time parameters in which for things to happen so it is timely. And I think with that, that's why the NICS check is discretionary, because they can choose to do it or choose not to do it. And maybe that needs to be better defined. I think to answer your question, yes, if someone files for a restraining order and within the 4 or 5 days there's found to be no standing and it's vacated, the judge could, in theory, right then and there say, okay, please, police department, give these guns back to the owner. The other side of that is if there's a temporary order that's out for a year, well, a lot of things can happen in a year. And certainly at the conclusion of that year, it makes sense that we want to make sure this person is not prohibited. I think the lieutenant was going to speak, and I won't steal her thunder unless she kicks me under the table, but to say that this may very well have the opposite effect, where the court is now relying heavily on our say-so. So we do a check, and then the court really, it kind of takes their discretion out of it the other way to say, well, we're going to rely on what the Department of Safety tells us and not really rule on it ourselves. So I guess it has that potential as well, if that makes sense. Am I saying that right?
I don't want to get argumentative here.
No, I understand.
But I really think that if this is something like this is going to happen, you really need to name the circumstances under which you're going to do a NICS check. And you also said that, 10 days, but, you want the ability to it could take 20 days, 30 days. That should not happen. If someone has been adjudicated, it's been dismissed, they should get their guns back immediately. But we agreed a few years back, 10 days to give the police departments the ability to process whatever paperwork they needed to. But now you're talking about 20 days, 30 days. That I don't see how this is going to work, quite frankly. But I appreciate you coming here. I just have too many questions, and I just can't see how this is going to work. But anyway, that's just me. So are there any other questions? Okay. Seeing none, thank you I hope I didn't scare people.
Thank you, ma'am.
Thank you very much. We appreciate you being here. The chair will call Robert Tangway.
Good afternoon. I might be able to help answer some of the questions that you guys had been following that. And I have 173B, which again is unconstitutional via Article 15 of the New Hampshire State Constitution, right to the accused. Take away someone's guns with 173B without a trial, criminal convictions. This is all done civilly. And so when you do this civilly, there's no due process. And it's kind of been lobbied by this organization called the Women's Bar Association in the state of New Hampshire. And if you go on their website, the Women's Bar Association's sole purpose is to, I call it gerrymander the family courts, but gain equity for women and families and women and children. That's the specific words. And I put that into a brief at the Supreme Court. So as for the timelines, I do agree with Senator Carson. And as far as the timelines, but maybe I could help explain that a little bit more. When you look at 173B extensions, basically what happens when you get a protection order, even though it's unconstitutional, but let's just pretend it's not, you go and you get an extension. From that point, the defendant gets to rebut that, say, no, I don't want an extension, or just let it be, and then it just gets passed. They always grant the extensions. They grant my extension before a hearing. They grant it, and they didn't even give me the reasons for it. They violated their own law, the court, by not giving me the reasons, and it's just a mess. But so the party, the protected party, would be able to say, hey, this person's dangerous. Then the court decides grant the extension of the protective order or not, deny the extension, and then it's released, and then we're involved with this. I believe, and I don't know if I said that I was against it or for it, but I am for this bill. It's not perfect, however, because it has 173B in there, again, unconstitutional. RSA 633 is human trafficking, interference with custody. I'm sorry, 633:7 is human trafficking. 33, I think, is stalking, which is just absurd. They're not real crimes, even though they're by statute. So the fail-safe is that the aggrieved party can say, I don't want this, and then the court can say approve or deny it. They pretty much always approve it. They already granted, they approved it because, in my case, because she was afraid of me speaking here. Literally. And I still have to send you guys the actual hearing. So now this bill, which I am in support of, there might be some amendments that you guys can fish through, but it creates a timeline and certainty with the police. They don't want to get sued, but it creates a 10-day timeline in which the Department of Safety must. And then there's an appeal process. Must, shall, must. And so that gives the people back their guns, which are a constitutional right and federally. I don't know the specific statute, I mean a specific case, but this is now recent. It's happening right now. Appealing in the federal appeals court that domestic violence petitions unlawfully, unconstitutionally remove gun rights from people. We can't precog crimes, and we want to prevent crimes, but the real way to prevent crimes is to fix the issues that are involved in our families, in our communities, that cause people to do crimes. People aren't just crazy. Why does a person steal food? Because they're hungry. And then you can extrapolate from that. So we need to get to the underlying issues. This bill seems to have come in a way where both parties have been, parties, groups, even the coalition, came up with that. So when you're looking at where it's discretionary, the court can at any time say, hey, we got to do a background check. But how likely is it that someone's going to get a domestic violence petition, then get go rob a convenience store, and then with a knife, and then not be allowed to have a gun? I don't know the specifics why you can't have a gun, but just if there's nothing apparent right away, give us back our guns. Another thing that I find is important, and I know I could talk for a while, but I think it is important. I don't know the specific case, but this is recent. Actually, no, I'm sorry. This was in the Republic, Should You Keep It, the audiobook. It's a great audiobook. It's all about the courts from a former federal justice. And he mentioned a case that was absurd, that the person was found not guilty of a crime through appeals, I believe, which prohibited him from having a gun. So it got overturned, the punishment. But because he went out and purchased a gun, the Supreme Court, US Supreme Court, upheld that because he was a felon and couldn't have a gun, even though this other charge, underlying charge, which made him a felon, was overturned, he was still culpable and therefore had a prison sentence. He lost on appeal at the Supreme Court because he knew that, or should have known, that he could not have a firearm at that point. So there's a lot going in there, but this bill, I believe I just read through it again, and hearing the testimony, I think that we should be able to go through. There might be some minor amendments, but there's all those process. This creates a process for the court, for the person to get their firearms back. And the court can do whatever they want, but they must do A, B, and C, Department of Safety and such. And that's my long-winded testimony.
Okay, thank you very much. Are there any questions for Mr. Tangway? Seeing none, thank
I
you.
appreciate you all. Thank you.
Okay, are there any other members of the public that would like to speak to House Bill 1339? Okay, seeing none, we'll close the public hearing. Thank you all very much. We've concluded our business of the day.